And let's go to the intellectual property issues relating to startups. Uh, I'll let you take it from here, and you tell me what you think
Yep.
are the important ones.
Well, first and foremost, absolutely, you must consider your budget because some of this you could probably do yourself. It's a very bad idea. Some of it you can't do yourself under pretty much any circumstances, and you will need legal assistance. And I'm not just talking my book here. I have made over my career almost as much money fixing the mistakes of people who filed their own things or used, you know, a company which shall not be named that's very fast in the legal business, fixing their mistakes as I have actually filing for my own clients. So you can pay me a little now, relatively speaking, or a lot later. It's kind of like plumbing, fix it the first time or expect to get wet. But in any event, once you've got your budget established, the two things that I would tell you to look at first are number one, do you need to register any trademarks for vital branding, whether it be the name of your company, the name of one of your product lines, anything like that? That you need to do that for two reasons. Number one, obviously, if you get a trademark registration, you can protect your branding much, much more easily. But the second one is almost as important, and in some ways more important, depending on how you count. It makes sure that you aren't infringing someone else's trademark, which is very easy to do. You want to get what we call a freedom to operate or a clearance search if you are really depending on a branding item, the name of your company or the name of your product.
I guess
Um,
it gets incredibly expensive if you do the production, the promotion, the marketing, the boxing and all that stuff, and then you get this letter from someone saying, Houston, we have a problem," kind of thing.
Yeah, and if they have, especially if they have a registration, I mean, they don't even need to have one. If they were just in the market before you, they still may have a very good case against you. But if they do have a registration and they decide to press it, you are probably in for a very expensive lesson in intellectual property. I've seen that happen to many startups, and it can be devastating, especially as Michael said, if you've already sunk thousands or tens of thousands into your branding physically, because that just all goes in the dumpster. You can't use it. So yes, so that's the first one. The trademark thing, consult your attorney, consider that very strongly. Trademark registrations are not what you'd call cheap, but they're not super expensive, especially if your attorney helps you decide on what the vital ones are. So that's number one. Number two would be patents. Do you have patentable inventions,
Yeah.
especially if they are
Let-
part of your? Okay, go ahead, Michael.
yeah, very quickly on the trademarks. Just because you have a registered trademark doesn't mean that you're bulletproof against the trademark infringement claim, correct?
Correct.
But there are statutory benefits to.
Enormous statutory
Okay,
benefit. Yes.
so why don't you just tell us a few of the statutory benefits of the trademark registration rather than relying simply on common law trademark
Sure.
registration? But yeah.
Um, what happens with the trademark registration process is the trademark office goes through your trademark application and gives you basically what is a very sound opinion on whether or not you should be allowed to use that trademark in the United States. Just because you have it, as Michael said, doesn't mean you automatically win, but it gives you a bunch of presumptions in court. Number one, first and foremost, if the trademark is registered with the USPTO, they have to prove that it isn't a valid trademark if they are claiming that. If it isn't registered, you have to prove that it is. Basically, the trademark office allows you to do that in advance. The statutory presumption, once it's registered, is that it is valid and that it is good for its market. And that means the other side has to disprove all of it, which is very hard to do sometimes and certainly can be very expensive. On the other hand, if you have to do it, it's expensive for you. You have to do maybe marketing surveys. There's a lot of different things. We won't dive into it. But without that registration, you have the burden of proof. Number two, if you have a registration, you may be eligible to get your attorney's fees paid if any suit arises, which again, attorneys are not cheap. And I say that as an attorney who I believe my fees are quite reasonable, but they are not what you would call cheap. But that it can be also huge, and it can also be a very strong incentive to the other side not to poke the bear unless they mean to chase it out of the game. Because once that happens and you start paying lawyers, they may be liable for your fees. So And also you can use the little circle R, which, stands for a lot of things. The circle R means registered trademark. And by the way, never use the circle R on something, even if it's a pending application. Never put the circle R on anything until you have the registration in your hands, because that is a violation of federal trade law, and it can get you in a lot of trouble, especially if a competitor finds out about it and uses it as leverage.
Then there's also the statutory damages, correct?
Correct. That is the other big, huge advantage, in that if you only rely on what we'd call a common law trademark or an unfair competition suit, you have to prove that you were damaged. Even if they did infringe it, if it didn't cause you any damage, they just painted it on their house or something, and never really did anything else, you can prove they infringed it. But if they can't show damages, you don't get any damages. There's no money for you. However, if it's registered, the statute provides for a certain minimum level of damages automatically. It depends on various factors, but it can be quite large, up into the $100,000 or more, depending on the infraction or the infringement. Sorry, but yeah, it's definitely the third huge advantage of the registration. Is you automatically get some money if you win, even if you have a hard time proving damage, which can be hard to do.
All right. I think we've covered enough on the trademark side. Let's get to the patents.
Yes, patents are more expensive almost always than trademarks. However, that is because they are very complicated. And Michael and I are both patent attorneys. We have separate law licenses just for that. That's how complicated it is. And you have to decide quickly, because in most of the world, if you disclose an invention, say you have an invention that you want to use, it's part of your startup's IP. It's one of your big assets. We have this great invention. We're going to monetize it with a startup. Classic corporation. In most of the world, if you disclose that invention to the public before you file a patent application, you are forever barred from filing a patent application in most countries. There are wiggle rooms, never say absolute in the law, but for the most part, you don't want to do that. The main exception to that is the United States, where there is a 1-year grace period, so to speak. It is also not absolute, but it's pretty strong. So if you only want a patent in the US and you've already disclosed it, which is a lot of people come to us and they say, oh, I already put up a YouTube video, I already, did some marketing, whatever, but I haven't patented my invention. Then we'll say, well, you can at least patent it in the US if it hasn't been a year. But once that year is up in the US, you're also forever barred from filing a patent application. So you have two clocks. One clock has 0 seconds on it, and one clock has a year on it. Once those clocks run out, that's it, no patent. So you must decide very quickly. Then you have to decide whether or not to file the patent. And there's a lot of strategic questions that go into that. How strong is the invention? How much money do you have to not only get the patent, but to enforce it? There are no patent police. If you get a patent and someone infringes it, it's on you to go after them. Once you do, you can get the money from them that you spent. But until you win, you get nothing, and you're paying your lawyers. Most patent attorneys, litigators, will not work on commission. They expect to be paid hourly, because this is a very uncertain field, and it's also extremely complicated. But if you have that patent, you need to file it as soon as possible. And there are things like provisional patent applications, other things that we can do. Again, that's a whole separate strategy podcast all by itself. But those are the first two. Number one, simple, straightforward trademarks. Number two, if we need a patent, get it.
And then,
Get it started.
but then there's also the considerations of trade secrets.
Right. You may, and that's one of the strategic things we discuss. Depending on what your invention is, or what secrets you have that make you competitive, you may decide to say, I'm not going to file a patent, because patent applications are published. Even if you don't get the patent, they are published after 18 months with few exceptions. And that means whatever it is going to be public knowledge. So if you don't get the patent, you have literally told your competitors exactly how to do what you do. Because if you don't, the patent application doesn't work. The patent application must disclose how to practice the invention in its entirety. So you might well, they'll never figure it out, or it's not that big a deal because only, the three of us know exactly the best way to do it. And if you don't file a patent application, you're not required to tell anybody how it works. Consider the famous Coca-Cola formula. They never filed a patent on it. It kept in that big vault in Atlanta somewhere, and only the people they trust enough to see it know what's in Coca-Cola. So if that's the case, they decided to go the trade secret route.
I think we've covered most. I mean, I know there's copyright issues and domain name issues and stuff, but I think we've covered enough for people to digest, at least initially.
There's a lot going on.
Of course, there's a number of other things, and we'll probably cover some of these other issues in a future podcast. Mark, thank you for being here and providing your valuable time. And to the audience, thank you for tuning in, and we look forward to seeing you on our next podcast of Unraveling Intellectual Property with Michael Stein. Take care, everyone.